Let me start by introducing each of our distinguished panel members. Shane Hansen practices law at the firm of Warner, Norcross, and Judd, based in Michigan. His areas of focus are financial services regulation, and including banks, broker-dealers, investment advisors, financial planners, and money managers. He advises clients about business, corporate banking, securities, franchise law, and regulations. He has significant M&A experience in sales of financial institutions and their assets. And as he mentioned earlier, he co-chairs the broker-dealer and investment advisor practice at WNJ. He's co-chair of the State Liaison Subcommittee Committee on State Securities Regulation in Michigan. And he's had a number of different involvements. He is the counsel to the AMNAA on the MAB initiative, which Shane has been a leader of from the get-go, and MBBI has supported both financially and in other ways. He was honored as one of the best lawyers in America in 07 and 08, and a Michigan super lawyer, can we see the cape later, in 2007. His law degree is at the University of Michigan, and his BA magna cum laude is at Albion College. Is that in Michigan? In Michigan as well. So please welcome Shane Hansen. Our other distinguished panelist, his firm is a sponsor of MBBI. He's a longstanding member of MBBI. Craig McCrone specializes in corporate law. He advises companies and boards regarding alliances, joint ventures, acquisitions, security offerings, director and officer liability, and financial institution regulatory matters. He was the lead attorney in the negotiation of the CBI no action letter, the most far-reaching, these are his words, the most far-reaching regulatory announcement regarding business brokers and acquisition advisors since the 1980s. His work includes transactional documentation and negotiation in Europe and Asia. Craig is a graduate of Harvard University and received his joint law degree from the University of Pennsylvania and MBA from U of P's Wharton School of Business. He was a graduate student in law and economics at the London School of Economics. Prior to entering private practice in Chicago, he worked with the legal staff of the United States Senate Committee on Banking, Housing, and Urban Affairs. So we're very honored that Craig could join us this morning. Please welcome Craig McCrone. The attendance today is demonstrative of the concern that we as intermediaries and brokers have on this critical issue. There's also, as we heard, a number of attorneys in the room who really want to understand the situation better. And we'll attempt through a series of questions and answers to get a good picture on the lay of the land on this issue in its many facets from Shane and Craig, and then leave ample time at the end for audience Q&A as well. So the format is that I'll be asking questions and asking either Craig or Shane to answer these questions. The first one is for Craig, and it's under existing law. Are business brokers required to register with the SEC in either an asset deal or in a stock deal?
One of the issues you have to decide, which is where do I fall in the continuum of brokerage activities? And on one end, you've got asset deals, which are, as you know, you just broker and work to advise companies in the sale of their assets. At the other, there it is. At the other extreme, you have capital raising, and we haven't talked about a lot of that today. Some of the larger brokers will work on capital raising, pure capital raising, and I can tell you that is the third rail of registration, as Shane will attest as well. If you were involved in capital raising, there's no exemptions, no get-out-of-jail-free card. Technically, you're supposed to register. Now, the question really is, Mike, what if you're in between, in this sort of gray area where you're brokering technically the stock of a business? And technically, you should register, unless there's an exemption, and that's what Shane and I have been working on over the years. Is there an exemption for the registration? But starting out of the gate, If technically you're working on a stock transaction, the law says that if you are affecting a transaction in securities, you need to be registered. That's federal law. And the court has said, and we'll talk about this with some other questions, that the stock of a company is a security, and that if you're brokering it, you're affecting it. So therefore, without an exemption, then this law would apply and all the parade of horribles that come with it.
Isn't there a sale of the business exception or exemption to the SEC registration requirements?
Yeah, there used to be, and until the mid-'80s, logic prevailed in the application of the Securities Exchange Act of 1934 and 33, the Securities Act of 1933, to the sale of business. Because if you think about it, if I'm a stockbroker on Wall Street brokering the shares of IBM, is that like advising a business on the sale of all of its stock? And until 1985, of course it was. I mean, it's different. It's fundamentally different. And the court, in my opinion, in an odd decision, decided that the language, the word stock is used in the definition of security in Landreth versus Landreth, and that applies whether it's 1% of the stock of a company or 100% of the stock of the company. And that was sort of the firing gun for a lot of confusion about the application of these rules to business brokers, and that really, at the end of the day, brought us to where we are today.
Next question for Shane. What can happen to a business broker who does a stock deal without registering with the SEC? And I've got a list: civil enforcement suit and fined by the SEC, civil enforcement suit and fined by Illinois or other state security commissioners, loss of the right to commission on a sale, the right of the buyer, this is scary, to rescind the stock sale. So can a buyer argue after the fact that the seller's representative was not registered and unwind the deal? And the potential liability of other parties to the transaction, seller, buyer, attorneys, accountants, etc.
Essentially, the questions that Mike has asked are the parade of horribles that Craig alludes to. And while you may not think of yourselves as stockbrokers when you broker the sale of a business, legally you are. You're regulated under the same system of federal and state securities laws as Merrill Lynch. And that's why it just doesn't make much sense, and why the profession of M&A, intermediaries and business brokers, have largely either willfully or unintentionally ignored this body of law. But there is a parade of horribles that can happen to you, and the securities laws apply from a very different perspective. You all work on deals, and from your party's perspective, it's something of an afterthought of what the legal form is going to be for the sale. But the legal form makes a huge difference in terms of the applicable law. And so, in fact, if you are brokering the sale of a business and you do that through the transfer, the issuance, exchange, purchase, sale of stock, or a merger, you are meeting the definition of a broker, which is someone who's engaged in the business of effecting transactions in securities for the account of others. Very broad definition. So the parade of horribles that can happen as a result of that is the list here. And I'm going to take these a little out of order because I'll hit what I think are the most important for you. And first and foremost, and closest to your pocketbook, is that your engagement agreement with the client is void. Not voidable, it's void. And if the other part, your client doesn't want to pay you, they don't have to pay you. And you cannot collect on a theory, equitable theory of law that I did all this work, I still ought to get paid. You not only lose your compensation, you will lose the expense reimbursement, you'll lose everything. The contract is void. So that will hit you near and dear to your pocketbook. Civil enforcement by the SEC and state regulators is minimal. I would tell you, you're just not on their radar screen unless a competitor complains or a client complains. That doesn't happen very often. It does happen more often than not in the context of raising capital, and I'll talk a little bit about one of the handouts where a competitor complained about a firm raising capital and the SEC brought an enforcement action. But unless you get on the radar screen for the regulators, you're not likely to, they're not out looking for you. Something's got to put you on their radar screen. Civil enforcement by the state of Illinois, minimal. Tanya Soloff, the Illinois Securities Commissioner, was the guest speaker at the AMNAA Summer Conference in August, and she said they've had a handful of complaints, 3 or 4 that she can remember in all the time she's been commissioner. So you're not likely to get the regulators barking down at your door. The right of a buyer to rescind the transaction, I'd have to say, is probably more theoretical. I haven't seen it, but the way state securities laws are written, and in particular California, but other states as well, if you buy a security from an unregistered, or through, not necessarily from, through an unregistered person, the way the law is written, the buyer has the right to rescind the transaction. That was written in the context of, think of yourselves as buying shares of General Motors stock. You know, that's the context that this was written. And if you weren't registered to be the broker, you bought General Motors stock from them, and now it turns out it's the old General Motors stock, not the new General Motors stock. And oh, by the way, that the intermediary wasn't registered, the buyer has the right to rescind the transaction. What that leaves you is a mess, because you've got a buyer who's rescinding the transaction, but a seller who may not have had, you know, if the intermediary represented the seller's probably got a problem. So I'd say more theoretical than real. I haven't seen cases raising the issue, but it's clearly out there. And California passed a statute a couple years ago that enhances the issue. So, and then just think of yourself as the intermediary who wasn't registered, and it's obvious that you violated the law. Any aspiring lawyer can come up with a laundry list of damages that they will hold you responsible for. If the deal fell apart, hey, this guy wasn't even licensed to do the deal, so he or she ought to be responsible for this whole mess.
The dynamic is how careful do you have to be, and how much risk do you take? So it's sort of, you have the Surgeon General on one hand saying if you eat broccoli, you're going to get cancer tomorrow. And then you've got the other extreme, which would be, I don't know, Michael Jackson's doctor injecting him with, anesthetic the day he dies. So somewhere in between is a responsible risk taker and weighing of the risks. So Shane and I, in working with our clients, are always in between. Hopefully we won't be on either extreme, like you have to bubble wrap yourself before you cross the street. Or go ahead and do anything and it's not a problem. But there's this constant tension between the reality of your business and the theory of the laws. And part of the lawyer's function is to filter some of that law and give you the risks. And that's what Shane and I will be balancing today. And it's frustrating because the law is a bit schizophrenic, going between these extremes of theoretical damages, but they don't really enforce it, and that's the challenge for us.
In the context of balancing the risk, Shane, have, to your knowledge, any business brokers been prosecuted for doing a stock deal without registering?
As you assess the risk, the regulators, to my knowledge, have not, in and of itself, gone out after somebody who just wasn't registered. Where the context comes up is usually where there's fraud involved, where there are other issues. And the registration violation is only one of the issues. But let me point out that in the context, to distinguish, because some of you may be involved in capital raising, and as Craig pointed out earlier, the third rail is raising capital, because it's just not a gray area. If you are out getting paid to raise capital, there are a couple of old SEC no action letters that simply don't apply in most cases. One of them is called Paul Anka. It is so narrow it will not apply to anybody who's doing it. It was basically the use of the singer, Paul Anka's Rolodex for the Ottawa Senators to raise capital. And in your book, I would point to page 64. is the SEC's case against Ram Capital Resources. And I highlight this for really two or 3 points. One is, this is a case where very likely it was a competitor that turned in Ram Capital Resources. As you read between the lines, it looks very much like it said that these people were told they were raising capital in PIPES transactions, private investment in public equity. And by the way, it doesn't matter whether it's publicly traded securities or privately traded securities. Stock is stock is stock. So anyway, they were charged by the SEC for raising capital and being unregistered. They gave up in $1 million settlement with the SEC all of their fees. All of their fees. They paid a fine. It wasn't just one transaction. They gave it up for all of their revenue. And they paid fines in addition to that. So, as Craig says, there's clearly a third rail, and a competitor may turn you in.
So that answers the next question. Have business brokers indeed have lost their commissions for doing a stock deal without registering?
They have, and I'll point you in the materials to a second handout. On page 54 of the materials is the Torsiello Capital Partners case. This is in New York State, although I would tell you that the law that's applied here is the same. It's federal law and state law, and it's going to be the same in any jurisdiction. And the Torsiello case is a case where the intermediary was not, in an M&A transaction, was not registered. They were not permitted to collect their $26,000 fee. They were required to disgorge the $50,000 retainer that was paid. They gave up all of their expense reimbursement, and they could not collect their fee. So this case, and I'd note is, and others, it's not the only one, is getting some play. The very last 2 pages, 70 and 71, is just an example of some of the play in the media or the legal press that these cases get. This is called Lexology. It's by the Association of Corporate Counsel. And it talks about, this goes out to lots of lawyers, and it talks about these cases. So actually, I would give credit to MBBI, AMNAA, IBBA for proactively dealing with this issue, because these issues are getting a lot more press today than they ever have.
So we've talked about the horribles, as Shane called them, and we alluded to exemptions, which provide situations in which we can operate without fear of these horribles. We're going to now look at the 4 major exemptions, 3 of which are available today, and 1 of which is an ongoing effort, and ask Craig and Shane to explain a little bit to us about each one and in what situations it does provide an umbrella of safety for people operating. The first is the Illinois Business Broker Registration Act. So, Craig, if somebody is registered as an Illinois business broker, to what extent does that protect them from the horribles?
Directly, it doesn't. It probably would be directly as relevant as having a fishing license to help you. But it doesn't mean it's not relevant, and it doesn't mean it wouldn't be very helpful. And I think it does mean that we, focus on it. And actually, that kickstarted a lot of the industry discussion today. Of course, the Illinois Business Brokers Act is something near and dear to a lot of us in this room. That act created this organization, and a lot of you remember, George Stevenson was the George Washington of the whole thing. He started, and actually Linda Purcell was involved as well. Mike Anacari was probably the business broker leader in doing it. And Mike and George and I spent many hours, several of them in my law firm, and negotiating. And Bill Wentz worked on the regulations, which, by the way, if you look at them today, a lot of the regulations in that act parallel a lot of what Bill Wentz did. So, kudos to Bill. And so that act is near and dear to all of our hearts. Talk about making lemonade out of lemons on that one. It started out as the Secretary of State. I'll try to make the story short. I'm just sort of waxing, passionately about this and nostalgically about this because of the association with the organization. But in a nutshell, the Secretary of State back in the mid-90s, they found the securities law and they found a Xerox copy machine, and they whited out the word, broker and put business broker in there, and then they got it passed in the legislature. And it was an insane law. It was sort of like the securities Taliban putting burqas on business brokers. It made no sense whatsoever. And so this group, the nucleus of this organization came together and pulled a good group of people together. We lobbied the Secretary of State. And then what lo and behold we had the great regulations come out. We were able to strip out some of the crazy stuff in the law, and then amazingly, we got a lien for business brokers, the only one in the United States, and it was incredible. The law, for those of you who aren't familiar with it, and I think most of you who are business brokers here, you're almost certainly registered. If you're brokering a business and the assets are in Illinois, or you're in Illinois, you're supposed to be registered as a business broker. $200, you fill out the form, you send it to the Secretary of State. Most or all of you have done that. Ironically, if you're a registered broker-dealer, you don't have to do that, but then you don't get the benefits of the lien. So you register as a broker, you're in Illinois, and then there's some disclosure obligations, and it's all laid out on the website. They're pretty clear. You have to give the contract up front, so on and so forth. There's some exemptions to the disclosure obligations. When we were talking about it with the Secretary of State and discussing, well, what kind of size threshold, and we were sort of throwing around this accredited investment investor standard, and it somehow got corrupted. And Shane will get a kick out of this. If the gross revenues of the business that you're selling exceeds $200,000, there's a disclosure exemption. But you probably want to do that anyway, because then you get the benefits of the lien. You don't want to upset the benefits of that lien, which is you can submit, it's like a UCC1, you submit it with the Secretary of State and you can secure it and get a lien on the assets. And I know a few of you in this room have done it, and it's saved more than a couple of commissions. So that's a long story about a law which, although isn't directly, will not get you off the hook. It will, number one, get you the lien, and number two, if these cases do come up, as Shane mentioned, what the lawyers will do is they'll look for any possible conceivable licensed registration that you need, claim you didn't have it, and tell a judge he didn't have his fishing license in Idaho on his vacation, take his lien away, take his commission away. So in Illinois, pay particular attention to it, but it's probably more positive than negative at the end of the day.
You were the champion and successfully got the CBI no action letter. Enlighten the group on what that covers, if you will. Yeah,
the CBI no action letter was a letter from the Securities and Exchange Commission in Washington, D.C., and I worked with the International Business Brokers Association on it, and there's a big overlap between this group and that. Linda Purcell was involved at the time. What we did actually worked a lot on the experience in Illinois, and then just built upon it and took it federally. I will note, having lobbied things in the state of Illinois, and this applies to most or all the states, and I've worked in Washington, D.C. on Capitol Hill, the dynamics are really different. And when Shane talks about the AMAA proposal, I mean, you guys have done a lot of work on it because it's a much harder, bigger process. The idea was we had this problem of the registration involved, and we talked to the SEC, and we talked to the SEC about a letter ruling, and at that we got a little lucky. We sort of hit them at just the right time, and so we had, with the MBBA, we had a lot of great organizations like yourself. We could pick a plaintiff we could select. This was Country Business Inc. in New Hampshire, and we went before the SEC, went down to Washington, talked to the head of the regulations there, who were responsible for broker-dealers, and they talked to the commissioners. And what we did was we negotiated something that would apply more directly to business brokers and that would address your transactions in a way that the prior letter rulings really hadn't. And that way, we were able to get at least some people off the hook. There are some limits, and we can talk about them. Now, that's sort of the oatmeal, the eating your vegetables part of my presentation, and it's to understand sort of what it is. So and what it isn't. You know, some people think it's a cure-all. It's like taking one of those pills on TV when you're suffering from some horrible disease. You take it and then you're running through a cartoon field of daisies in the commercials and you're all healthy again. Not quite that. However, it is more than a sugar pill and a glass of water. So one of the fundamental restrictions of CBI, which is an exemption, it's a recommendation. It's sort of the interpretation of the Securities and Exchange Commission of their laws. And we'll talk about sort of where the letter ruling falls. It's highly influential. It's not as binding as a regulation. It's probably more binding than a state court case, but it's extremely influential, a letter ruling. There's hundreds of, I think I did a search, about 355 state and federal cases referred to private letter rulings of the SEC, just to give you an idea. There's about 4,000 scholarly articles that talk about securities matters that refer to private letter rulings. So these things are important. In particular, when we negotiated with the SEC told us, and this is sort of the what isn't in the letter, but part I think that's relevant. The head of the markets division of markets and trading, told us they wanted to use this as a vehicle to create a letter that was broader and more completely explained so it would address this issue. They didn't want, and I won't bore you with the history of the letter rulings, but there was a highway littered with the wreckage of these very poorly delivered letter rulings. Like, I was using the analogies, like a pink Cadillac in Idaho, 3 wheels, and my transmission's out. It's so specific as to the facts, the prior letters, that they really provided very little protection for you. So we specifically negotiated with that, and the SEC actually was eager to do that with us. Now, I'll try to condense this. This will probably be the longer answer to my questions today, and then they'll get, Mike, they'll get shorter, honest. But it's very important to understand what it is. Now, the basics. What we did was we negotiated a setup for an acquisition, and we did it in a way, we worked with a plaintiff in the way that they were contemplating a variety of transactions, because the critical nature of this letter, probably the most important word in the CBI letter, which by the way is reproduced in the materials here, the most important word in that letter is or. We intentionally put a lot of alternative transactions and alternative compensations and alternative activities on your part with no accident, because we wanted this very robust laundry list that the SEC said you can do this, you can do this, you can do this. You can't do everything, but we didn't say we're only doing this and 1, A, B, and C. That's all we're doing. It's a very long list. So it makes for a longer letter, but also a broader letter. So we're assisting with a business. It could be an asset deal. It may be converted into a stock deal, which is critical. Now, in terms of compliance, the whole theory of this thing, and I don't know if this is going to work. Let's see if this thing, if we can get this back. Yeah, I have 3 slides today. You'll be subjected to 2 of them. This is my picture of the whole theoretical construct of securities laws as it applies to you. You've got this, the law which says you can't affect a transaction, so affecting securities transactions. And this relates a lot to what Shane's doing as well. So the way I looked at it, and I think it's very relevant, there's sort of 2 paths you can go down. And this is important for you to understand CBI and the AMAA proposal. There's 2 roads you can go down. One is you can concede that there's a security. And that's like Shane. I mean, I'll concede there's a security, but I want to get exemption or I want a special regulation. There was a whole litany of what they called finder's letters, and that was that Paul Anka letter that Shane had referred to. And finders, for those of you who don't deal with kind of the shadows of capital raising, for years, and to this day, people do it. They try to claim there's an exemption from capital raising and registration requirements because I didn't affect a transaction in securities. I just found the buyer. I gave a list of names. That's all I did. The SEC historically said that was fine, and there was a lot of second thoughts on that. Oh, it's a really bad idea because it was abused. The business broker exemption for years was they tried to shoehorn it in this finder's exemption, and the shoe didn't fit. But it's a critical exemption because that's sort of, if you concede securities, you go down one road. Now here is the critical distinction with CBI, and it's the other road, is yeah, we were affecting a transaction and we were working down that road, but it's not a security because it's fundamentally, we're going back to the Landreth versus Landreth back to 1985. It's really the whole business. And the SEC, by the way, was extremely sympathetic with our view and the illogic of that 1985 Supreme Court case. But the question is, how do you get around it? So the fundamental approach to CBI was you advertise the sale of the business, assets or the sale of the business. You don't advertise securities when you're doing your books or whatever. And then at the moment when hopefully the lawyer and the tax counsel, advisors, whatever, will decide to flip it to a securities transaction, okay, it becomes a securities transaction, you will limit your activities somewhat. We'll talk about those. So therefore, you're not affecting it. So you can do everything up to the point it flips, and when it flips, then you just have to curtail your activities somewhat. The idea, by the way, if you read all these weird requirements, it's the SEC's way of trying to construct a list of activities where you're working on an asset deal. And I'm jumping ahead here a little bit, but for example, a real hang-up they had, and what they wanted to focus on it was, well, you're not affecting a transaction, you're just valuing the business. And that's actually very helpful for you. So if you think about it, valuing the business is basically 99% of what you do other than forcing them to close the sale. Because you're telling them, is this a good deal or a bad deal? Structure good or bad? Fundamental valuation issue. So what they thought was, okay, you can value the business even when it's a securities transaction, but that won't be affecting the sale of the security. So they try to keep it in this, it's not, it's a sale of a business. And that's all these things relate to. Anyway, that's a long theoretical discourse, but very important to understand this laundry list of CBI stuff, because otherwise it looks pretty arbitrary, like where did they come up with this? And so only the assets are initially advertised. It could be assets or business in your listings. The decision to flip it to a securities deal is made by not you, anybody but you, which by the way, and I won't go into too much detail now, but when I'm working with business brokers on their engagement letters, sometimes we will put in language that mimics a little bit of this and protects you, so if they come back and say, I don't want to give you the commission, we can point back to the engagement letter that they signed at the time, like who would make the decision on flipping into a securities transaction, so on and so forth. Now, what can you do after it flips? This is really important. You can transmit documents. Okay, fine. That actually sounds trivial, but it was important. We wanted to be able to keep the business broker involved in the transaction. You can value the assets as a going concern. Critical. That keeps you basically between doing the admin work and valuing the business. Everything but like putting the hands together and making them shake, you can do. You can assist with the preparation of financial statements. You can talk to lenders, all that. As Shane mentioned, the third rail, you can't do capital raising. We were able to get a carve out for loans, because loans, and we can go into it later if you want to, are not securities. We got a carve out for loans. You can help them get a loan. You just can't help them raise capital from third parties, like through stock sales or whatever, to do the deal. Now, you could be at the table. You can't otherwise be involved in the negotiations. There's a little bit of confusion there. But if you look at what you can do, and this, by the way, was sitting in the room looking in the eyes of the SEC staff and senior counsel, and they agreed with this, is you can do just about everything substantively you would want to have done to sell the business. What they don't want, this is really where they're coming from, what they don't want are Sharpies and crooks finding this letter and using it as an escape valve and an excuse to sell stock to widows and orphans. They are, by the way, and Shane and I will talk about this, behind the the backdrop of this whole thing, securities regulators are terrified of the thousands and thousands of bad people out there who actually flim-flam innocent people. They're not in this room. They've never been in this room, at least not at our meetings anyway. Maybe the flim-flam meeting was here later on. But they are
who are planning to stay for the flim-flam.
Okay, all right, yes, it seemed like. They are terrified of that. They get complaints about it all the time. And then that's a context you just don't see in this letter. Why would you? Again, it's not your world. They are terrified of that. And that's why when they construct this, they don't want you to otherwise sort of negotiate the sale of that security. They want to hold back a little bit. They're not thinking of you. They're thinking of all the bad people who will exploit this letter and everything else. And a lot of these court cases, by the way, the recurring theme in most of them, and I'll make it a little shorter here, the recurring theme is, if you look at the cases and everything else, it's these bad people who are exploiting a loophole and selling lots of stock and not being registered, and it's in a lot of these cases, and it's annoying because you get caught up in that fact pattern. Now, there's a few other issues. One thing, and I'll sort of cut to the chase, but there's a lot of other important components to this. Compensation, the value of negotiating this, and although I do securities and financial regulatory work, I'm fundamentally a deal lawyer. M&A, I live in your world. And so therefore, when we're at the SEC, those people are completely not in your world. They are all about compliance and regulation. So you have to educate them. So we were able to educate them on the types of compensation. You take a look at that in the CBI checklist, which, by the way, the CBI letter's there and some slides are there. I'm working with a group of people, and we're putting together the CBI cheat sheet. So if you're doing a deal, you take it out. It's like the Betty Crocker cookbook, and you follow it. If you're interested in it, give me your card, and we'll get a copy to you. It's just a cheat sheet to the whole thing, and then that way I can get to the next questions. One thing on the size standards, another element was it only applies to small businesses. And this came up in the SEC, so we're sitting there, we're negotiating it, last minute, oh, size standards. We don't want someone doing $1 billion. We don't want Mike Milliken doing a deal under the guise of this letter. So you're going to put some size standards. How about, I don't know, $5 million for your business or revenue, whatever. Well, that's going down the wrong road. Again, we were deal people, they were compliance people. They didn't understand valuation of businesses. It's very flexible. So what we were able to do was take the small business standards of the SBA, Department of Commerce, and I was familiar with them because I worked a lot with private equity funds and SBIC qualified. So it was this beautiful, juicy set of rules that we found, and the whole rationale, as stated in the regulations, is we hereby issue these rules on size standards for small businesses for application to all regulations and statutes of the United States government. That's a beautiful thing, because if you look at these size standards, and by the way, they're in the packet. You can get them on the internet, and they're also in the materials you have. I mean, just to give you a sense, manufacturing companies, depending on the sub-industry, 500 to 1,000 employees. You've got transportation, up to 1,500 employees, banks, $175 million in assets. You've got professional service firms, you can go up to about 30 million, construction firms, 30 million. So you've got enterprise value here, which theoretically could exceed $100 million, which obviously, a lot of you wouldn't work on those deals typically, but it's a ceiling that gets rid of the large companies, but a lot of the smaller businesses can operate under that. Now, for some, particularly in a robust economy, now we're in a down cycle, but when it's an up cycle, more than a few of you may in fact hit that, and that's where you get the AMAA proposal. And why don't I'll stop there, but we're so focused on the smaller deals now, we forget about the upside on the good years. And when you're on the upside, you hit these levels. I mean, a $100 million deal isn't impossible. And that's when the AMAA came in and looked at how they could sort of take it for the bigger deals.
Okay. Craig mentioned again the MAB exemption proposal. Shane, would you describe that to us?
Sure, I'd be happy to. And in the materials, you'll find more detail. If you look starting on page 28 of the bound book, this goes through what the MAB proposal is, and there's a related proposal. We call it the small business sale transaction exemption that would take the CBI letter that Craig describes and turn it into an SEC rule. It codifies all of the things he's been talking about and adds a couple bells and whistles and would make it an SEC rule. So briefly, the M&A proposal started out with just briefly, the context. We figured we're not going to be able to get Congress to change the securities laws written in 1933 and 1934. We're not going to get 50 state legislatures to change state securities laws. And these laws are on the books today, so we got to work within that context. So what we proposed is a system of simplified regulation that would create an exemption from SEC registration of an M&A firm. And if you exempt SEC registration, it also, and very importantly, exempts you from having to be a member of FINRA, the Financial Industry Regulatory Authority that everybody else used to remember as NASD, or the National Association of Securities Dealers. Name changed when it merged with the New York Stock Exchange's regulatory arm. It's now called FINRA for short. And it would exempt you from having to be a member of FINRA. Huge regulatory relief because the bulk of the burden on registered broker-dealers today comes from FINRA, which is a self-regulatory organization. It's the deputy, if you will, of the SEC, the sheriff. The SEC looks over FINRA's shoulder, but FINRA does the bulk of the regulation. So it would exempt you from that. And in its place, it would look to the states to regulate the M&A broker on a simplified basis. You would have to register in your home state on an annual basis. This is what broker-dealers have to do today. But you would register just the firm. You wouldn't have to register all of your individual representatives. And you would do that on an annual basis. You would make notice filings in any state where you might have a party who's located. Understand that state securities laws apply if you have a party that you're dealing with located in another state. Let's say you have a client who's buying a business and the buyer is in Michigan. You're in Chicago. You'd have to be, under securities laws, you have to be registered in Michigan as well as Chicago. So we've dealt with that with a proposal that you would notice file, which is a euphemism for saying you send them a copy of some stuff you don't actually register. You'd send them what you filed in your home state. And you could do that anytime up until the deal closes. So you would not have to do that in advance, recognizing you could have buyers or, anywhere around the country. And theoretically, any one of those state securities laws would apply. You would also have a couple of other requirements, and these were requirements that were geared to getting the regulators to buy into this. Because, as Craig says, their mantra is investor protection, investor protection, investor protection. And they will not do something that looks deregulatory in this environment, let alone when we started. But in today's environment, deregulatory is a bad word. So we built into the program, to the proposal, a couple of features that are very easy to comply with. One, you'd have to have a written disclosure document. This tracks very much what federal and state securities law requires today for investment advisors. It's who you are, who your people are, what you do, and importantly, disclosing whatever conflicts of interest you have, like you represent both sides of the deal or you're getting paid in some other way. But it's disclosure. That's another mantra of the regulators. Disclose, disclose, disclose. You'd have to have a written engagement. Most of you do that today because you've got to spell out what your fees are going to be. And you'd be required to maintain some basic business records, far short of what broker-dealers today have to maintain. Basically your deal records, how you're complying with this exemption, and you'd have to have a compliance manual. How do I comply with federal and state securities laws? Understand, those laws apply to you today. So it's helpful to know what they are, not just affecting your registration, but how it affects your firm and, more importantly, perhaps, your clients, because those laws apply to them too. So the proposal is outlined in the materials in the book. To qualify, you would not have to sell the whole business. You could sell part of the business. The buyer would have to be an active buyer. This is to distinguish, as Craig points out, the widows and orphans. You want to have people who are actively involved in running the business, who are buying the business. And that's to distinguish it from passive type investors. So in a nutshell, that's the proposal. It's been presented to the SEC staff going back 2 years now. We added the small business sale exemption that codifies CBI in March of 2008. A parallel model rule proposal has been submitted to NASA, which is the State Securities Regulators Organization. It's the North American Securities Administrators Association. It's the organization of state securities regulators that coordinate state efforts. And believe me, it's a little bit like herding cats. Every state's got its own issues, its own personalities, but by going to NASA to develop a model state rule, NASA, when approved, would recommend this as a model rule, and states, for want of their own resources, very often follow what those model recommendations are. So we get a federal exemption and a simplified system of state regulation.
You know, just to distinguish it, one of the values of the MAB proposal is with CBI, you sort of you can't completely affect that securities transaction, but with the MAB proposal is you go all the way. With the broker-dealer light registration, you can do all of the activities. There are no there are no constraints on what you do. So that sort of picks up where CBI leaves off.
Right.
Yep.
We're going to ask some more questions of Shane about when and how likely MAB is to get approved. But first, everybody's read about the FINRA Series 79. And many people are wondering, does that mean my firm needs to become a broker-dealer? So we'll ask Shane to fill us in on the FINRA Series 79.
Sure. Let me back up one step to say what FINRA is again. FINRA is a self-regulatory organization of member firms. These are firms that are registered with the SEC, hence are required to be members of FINRA. FINRA has no jurisdiction on you if you're not a member. It's a self-regulatory organization of member firms. So, number one, if you're not registered, this rule has nothing to do with you. Secondly, neither FINRA nor the SEC go out and enforce FINRA rules against people who aren't members. These rules are designed to regulate the profession of registered broker-dealers. So, it doesn't have a direct application to you at all. I would also add what it is. The Series 79 is simply a competency exam. It's like what you all have heard referred to as a Series 7 or a Series 62. These are just labels attached to an exam that tests the competency of the individual in the field of their profession. What is good about the Series 79, if you are registered as an individual with a fully registered broker-dealer, what it will do, if you're not registered today, it will create, come November 2, an exam, 175 questions, 5 hours to take, an exam that is way more relevant to what you do than what the Series 7 does today, which is a general securities exam. It's not perfect because it applies to a whole bunch of activities that a Wall Street firm in New York City would be concerned about. Managing a syndication of a public offering, market stabilization activities. It's the things that, if you think of investment banking, what people do in publicly traded transactions. So there's a whole half of this that still doesn't really apply to what this group would do. For this group, it is indicative of what kinds of activities are considered to be regulated. But the rule itself, it has no application to you if you are not currently registered with a broker-dealer or don't become registered with a broker-dealer.
Thanks. Now let's go back to MAB. Shane, realistically, what is the likelihood and timing for the SEC to take action on MAB?
We thought we were very close to this coming out back late last year. We've been working with the SEC staff. The staff have been very supportive. Really, their only critical comments, critical is not even right the word, their only comments on the proposal were twofold. One, in keeping with Craig's comment, should there be a size cap on this? How large a deal should we be able to do? Our proposal does not have a size cap on it. The distinction we drew was to say you simply could not sell a publicly traded company. Obviously, you have a whole bunch of issues with publicly traded stock that you really got to know what you're doing in order to deal with. And that was our only distinction. You could represent a publicly traded buyer to buy a business, but you couldn't give advice about IPOs or the market value of the stock. You couldn't do the things that require you to have a knowledge of publicly traded securities. The SEC doesn't know what they're going to do about this. There's a blue ribbon panel of M&A firms put together an analysis in a white paper that, number one, analyzes different methodologies for measurement, because we don't want the SEC to seize upon one and say, you know, we're going to measure it by asset size or deal price. Things that you don't know going into it up front necessarily, or may not be a good measure. EBITDA may be a much better measure, or normalized EBITDA. So that was really, and the other comment the staff had was, should there be competency testing, what I talked about on the Series 79 exam. And this is not something the SEC would require. They raised that only as something that the states might require. So those are really the only questions that they had. The staff have been supportive. The key, of course, is getting the 5 commissioners, the board of directors, if you will, of the SEC to say, this is a priority for us, we want you to move ahead with it. And if you read the paper starting, around early fall last year, you could see there were a few other things on the SEC's plate. And they pretty much cleared the deck of normal workflow. The scandal with the Bernie Madoff issues, and frankly a bunch more smaller Ponzi schemes, along with a whole bunch of failures in financial services regulation have absolutely consumed their attention. They've made a lot of headway. Right now they're still dealing with what the Obama administration is proposing in terms of regulatory reforms. And so we know that their attention is still focused on those kinds of issues. But I met in May with the senior SEC staffers who've been working on this, and they've said that very confidentially, I'm saying it to you to let you in on the scope of the audience here, but they said, you know, we can't get out in front of this. We can't say what our bosses, the 5 commissioners, are going to do about this. So they're always very reticent about telling you where things are in the process. We wrote a 27-page article for the NASA's fall conference coming up later this month my partner is speaking at. And we put a footnote in there that said that we thought the staff was pretty much done with all the work that they needed to do on this. And I got a phone call. It was delivered to the SEC because they're going to be on the panel too. And I got a phone call from the senior SEC staffer, virtually apoplectic, that I had this sentence in a footnote that said the staff was pretty much done with this, because the staff do not want to be seen as being out in front of their bosses, the five commissioners. So I think that once we clear the crisis du jour, and we clearly got some legislation kicking around Congress that is going to continue to capture their attention, we think we're in good shape with the SEC. We wrote a letter on page 3 of your handout to the SEC, July 31, to the commissioners, trying to get their attention. We've got the staff's attention. Now we're working on getting the commissioners' attention. So also in the materials, you would find some other things that reflect the regulatory interest in this. SEC annually holds a forum at their headquarters. And at the November 2008 forum, Mike Ribbett and I were among the panelists at a program that the SEC, a panel that the SEC put together to talk about this, M&A as well as the private placement broker proposal. The SEC staff are very supportive of this, but they won't tell you that publicly because they're not going to get out in front of their bosses. The result of that, also in the materials, is a recommendation from that forum to the SEC commissioners recommending adoption of this. And you'll also see, as I mentioned, that come later this month, my partner is going to be talking in front of all of the NASA state securities regulators on a panel moderated by Tanya Soloff, your Illinois commissioner, and having an SEC representative who's going to travel out to Denver to talk about it. So it's a long way of saying that there's a lot of support for it, both at federal and state, but we just don't know when the commission is going to take it up because they've been dealing with all of these crises at the federal level.
We're now going to try to get two different points of view on, with the CBI no action letter in place, do we really need MAB? And that's essentially the question. And going out of the sequence, let's pose it first to Craig and then ask Shane to respond to that.
The CBI letter has two limitations. One is the size, which if you're doing smaller mid-market deals is not going to be a problem. But if on a good year you're doing the bigger ones, $100 million plus deals or $50 million plus deals, and you're getting the commissions for those, you know, that could be an issue. Number two, if for whatever reason you want to do, you know, even if 99% of your activities is not enough, if you have to be at the table and if you have to be sort of ahead of the lawyer on making some of those decisions about the securities transaction, if you don't have to be, CBI works, because you can do everything else in your job. But if you do have to be, the pavement runs out on CBI and you need to pick it up with MAB. So I think they're fairly complementary in what they're trying to do.
The principal shortcomings you should understand of CBI, and it's just, I think, driven by the SEC staff, and Craig could comment on it, it only covers seller-side engagements. It doesn't cover a buy-side engagement. And the SEC staff are very particular about what they'll allow and not for the reasons Craig describes. But it doesn't give you any help on a buy-side engagement. You also have to sell the entire business. You can't sell less than. You can't, you know, bring in a private equity group and still keep the other people there. You got to sell the entire business. And your compensation is cash. You can't take a contingent, you know, like warrants or options or that sort of thing. And the small business sale transaction exemption that we, as a companion to the rulemaking proposal, incorporates that. And it also lays it out in terms of a rule. It's more of what you and I would be used to reading as a rule. You can do these things. As Craig has pointed out earlier, no action letters, there's a good description on page 58 of that Torciello case. You'll see how these no action letters can come into play. Because on page 58, the court in that New York case said, Securities and Exchange Commission no action letters are prepared by the SEC Staff Counsel. They are purely advisory and do not constitute binding precedent, and it cites an earlier no action letter, the IBEC, or International Business Exchange Corporation letter. And this is important. It is exactly what Craig said. However, they may be found persuasive, emphasize persuasive in the interpretation of federal securities laws and regulations, and they cite a case. The exemption also has a companion that it would be applied at the state level, a model state rule, again, to codify CBI into a state rule, because federal law is federal law. State securities laws are often construed consistent with federal law, but you have to understand that it's not, the SEC's interpretations are not binding on a state court or even on a federal court. But at the state level, it's state securities law, and so the proposed rule would actually do the same thing at the state level, to take the very concepts that Craig and IBBA worked hard to negotiate and got in place, and to extend it explicitly at the state level as well.
A couple of thoughts on the whether it applies to a buy-side engagement. It doesn't say buy-side, but we talked about the SEC. I mean, they didn't think that some of the theory was particularly inapplicable. One thing to think about when you're constructing your engagements and following through on your engagements, the SEC did a nice job of outlining the legal theories and the facts you need to show that you're not affecting a securities transaction. That'll be applicable whether it's buy side or sell side. So if you follow it as a roadmap, you'll be in pretty good shape. It also, you know, actually when Tanya was at the conference last year in January, she said, and she acknowledged it lays a very good roadmap, and she also said, if you go outside of those bounds, you're definitely at high risk. And her point being, it does set forth a fairly coherent rule standard that even the state of Illinois can follow, and the courts can follow. So I wouldn't diminish it too much, but it does, it gives you the legal theory and the roadmap for the facts you can follow. So I think it does apply a little bit to the buy side. And even if it's not binding law, the SEC thought it through well enough and looked at the case law well enough and looked at how it lined up well enough that if you presented it in court, even if you didn't honor the words of CBI, it lays out your case for you, for a judge.
So I think that was very helpful. I've made some notes as well on where CBI doesn't cover you, why MAB would still be desirable, but the fact is we don't know when and if MAB is going to be approved. So it's very important to know when we can use CBI to cover what we're doing. I have one last question, and then we're going to open the floor to your questions. Can a business broker solve their problem by co-brokering every stock deal with a registered broker-dealer? And we'll ask both Shane and Craig if they have a comment on that.
Sure, I can answer. The answer is no. And it's, if you're not registered, a registered firm, a broker-dealer, cannot share a securities commission with an unregistered person. Similarly, a model for compliance would be individually, if your own firm is not registered to be a broker-dealer, individually you could register with a fully registered firm. And there are a number of firms that specialize in M&A and capital raising, and they'd be pleased to bring you on, in effect, on a sort of a part-time basis as an independent contractor. So when you hit a securities transaction, or you need to raise capital, or it doesn't fit the CBI letter, you'd have your engagement written so that it would be assignable to the fully registered firm. The firm then is responsible for it. The compensation gets paid to the fully registered broker-dealer when the deal closes. The broker-dealer pays you, their registered representative, but you can't share your commission with somebody who isn't registered. So if you're in a firm of 4 or 5 partners, they all have to be registered with the broker-dealer because the guys or gals who are not registered are not going to be able to share in the securities compensation that's paid by the broker-dealer.
Yeah, one thing that some of my clients are doing is, number one, they'll actually create 2 entities, one which is registered and one which isn't. And they'll run any of the CBI qualified deals through the unregistered entity, and they get to keep all their fees. And they'll run the non-CBI qualified deals through a co-brokering arrangement with a registered BD or through their fully registered affiliated entity. So that way, because the bottom line is, even if you could co-broker, you leave a lot of money on the table potentially. And as Shane mentioned, what you want to do, if you do have to do that, and if you do have your Series 7 or Series 63, you have to find the few broker-dealers who understand your business, because it's very risky for them, for like a Merrill Lynch to team up with you if they don't understand the M&A business. So you have to find the small number that do that. And I get calls a lot because I deal with those. So if you're interested in finding out which ones sort of specialize in it, feel free to come up and ask me, and we can get you some names. But otherwise, you leave a lot of money on the table, like 20%, 30% of your commission.
And understand the reason for that is that they are fully liable for the deal. And the SEC and FINRA and the state securities regulators will come in and audit them roughly every 18 months to 2 years. And so they have to be able to justify the transaction. It's got to be all the T's dotted, I's dotted, T's crossed. And they have to maintain that cost, the ongoing compliance cost, whether you're doing deals or not. And so that's why they'll hit you for a big chunk of the change, because they have a lot of overhead that they have to support. which is a factor in your own thinking about analyzing whether you should be individually registered with a third-party broker-dealer or whether you should register your own firm.
Okay, we're going to open the floor to questions. I'm going to repeat the question for the purpose of the video recording. At the time of LOI, if it's determined at that point that it's going to be a stock deal, will you still be able to get the protection of the CBI no action letter?
Yes, what you can do is you can avail yourself of the laundry list of activities that you can engage in, but it does definitely switch where you cannot be the broker cannot be the person to make that decision or to, quote, affect the securities transaction. So they can't be out front on consummating that transaction. However, if you look at what they can do, which is they can still help value the business, which if you look at the letter rulings in the court cases, valuation is the bulk of evaluating the structure of an offer, evaluating in the context of that business, evaluating the financials of that business, evaluating the financial future of the business, evaluating the industry of that business. It's the bulk of what you do. Secondly, you can assist with the administrative work. It sounds, well, so what? It's critical because some of the earlier letter rulings said you couldn't. So what you can do is you can be at the table, you can talk to your client, you can get materials, you can transmit more books, you can transmit supplemental financial statements. So you can do almost everything you're going to do otherwise, but you can't sort of be the one to say, close this deal, sale of stock. So it doesn't limit you that much. Now, another comment on the structure of the letter of intent. If you're not sure and you want that broker to be involved a bit more thoroughly in a longer process, you can put some provisions in the letter of intent that say, well, if it's a stock deal, this is what we're going to do. Or if it's an asset deal, we'll do something else. You put it in the letter of intent, so at least that way you're on record that, well, we're 99% sure it's going to be stock, we're not 100% sure. If you can leave a little bit of flexibility so that the lawyer later on can make the final decision, you can extend that deadline. But even if you get it, there's a lot they can do.
I'd just add to that, make sure there are lawyers involved so that the lawyers can do the negotiation and the structuring. So it's apparent that when the deal does get closed, that it wasn't the intermediary who did it, in effect, that there were lawyers who were doing lawyerly things for an hourly fee, and that there was somebody else affecting the transaction.
If it is a stock transaction, what are some of the risks? For example, will the transaction be reversed or rescinded? Now, we're assuming you blow through all the CBI gates and there's just the pieces of wood on the road and you've done the stock deal. Oops. What are your risks? Then you get theoretically the parade of horribles. But in a way, the nice thing about CBI is it creates this roadmap for facts that your lawyer can then adduce and say, it's not an open and shut case because he did these things and those things, so it's going to be a little harder to steal your commission that way. But if you did blow it completely, what are the chances of it happening? Low, but if I were the lawyer on the other side, number one, I didn't want to pay your commission. Number two, I think there is a risk it could be brought up. By the way, we haven't talked about real estate licenses and other things. They're going to throw a lot of things against the wall. That'll be one of many. So I would keep that in mind. I mean, if you can keep it within on the CBI highway, it helps. Usually those cases will come up before some of the applicable statute of limitations. You could have contractual statutes of limitations. Sometimes you don't have any on some of these laws. I'd say that defense is, boy, Shane, I haven't seen it in any of the cases come up that I've seen.
Like I said in my earlier remarks, the risk of rescission is out there. I've not seen it, frankly. It would take somebody to do some digging who knew, frankly, a securities lawyer, not your general litigator, to understand that. There are statute of limitations on registration violations, and there is usually two parts. One is from the date you knew or should have known the person wasn't registered. So that might happen early on, or usually an outside date. And so it is possible that the statute of limitations could run on those kinds of claims. But again, I haven't seen a lot of that. I think I wouldn't discount the risk, but I haven't seen reported cases on it. Capital raising is asking anybody to give money to debt or equity, and if you are soliciting an investment from someone, and it doesn't matter whether it's a widow and orphan or a private equity group, if you
No.
distinguish that a bank loan is entirely different. A bank loan is not a security.
Where's the line? Who can you go to money for? Who can you not go to money for?
Well, it's essentially outside of a bank, which is a traditional, it's indebtedness, and it's a type of indebtedness that courts have recognized is not a security. The definition, I'll backtrack one step. The definition of a security is very broad. The definition was written to cast a wide safety net over all kinds of things that you wouldn't necessarily think are securities. A note or evidence of indebtedness is in the list, and a note is presumed to be a security unless it meets one of a list of court-considered factors, and a bank loan is one of those that is not considered to be a security.
I mean, the rough rule of thumb is if it's a loan from a bank, you're okay. If it's just about anything else, you're not.
If it's not a commission or success fee, but a consulting fee, is that another way to collect?
Yeah, when we were negotiating CBI, I mean, that issue came up. The nature of the fee is less relevant than those other criteria, because I get that question a lot. Hey, it'll just be a consulting agreement and I won't have to worry about it. Not really relevant. I mean, the SEC and the rules really look past that. And they may look at whether or not you've got a commission based on the percentage of the raise, but the way the CBI letter is written, they really move way past that. The form of the commission is not relevant. What you do is relevant. And for the MAB proposal, it's totally irrelevant because you can do it. Under CBI, can the advisor provide advice regarding the pros and cons of an asset versus stock transaction? I think they could in the context of value. But I think they have to be very careful about not advising whether or not to do it. That definitely should be made by another party. Under CBI, could a broker value the stock of the company? The answer is yes, but you would be advised to follow the language of CBI, which is if you value the stock, to value the stock, you have to value the business, and then you just divide it by the number of shares. So when you're doing it, make sure that your letters or proposals and discussion talk about the value of the business and then sort of relate, and then they can kind of divide it by the stock price. You cannot look at stock markets. I'll tell you, if there's some public, if there's pure stock coming from the other side, you probably couldn't evaluate that security, the structure of that security. That'd be a little dicey. Does the presence of a seller note potentially introduce a risk? Does it make the contract void? It's interesting, Shane and I were talking about this when we were preparing for the panel. The reality is no, in all likelihood no, for a couple of reasons. One, the seller note, it generally doesn't follow, as Shane alluded to, the family resemblance test under debt securities. And some of the criteria are the intent of the parties, was it supposed to be a passive investment or an active investment, the method of distribution, were you calling lots of people, doing cold calls, selling that note, which obviously in a seller note, no. And was it really the work of somebody else, or were you involved, or was there some component where the recipient of that note could affect the payment of it. And there's a case, actually Shane and I were chatting, there's a case in New Jersey, it's a 2006 case, the Meredith case, and they looked at that, is the seller note a security? They concluded, no, it's not. But just so that you're not confused, because Shane is still correct, once you get into that family resemblance, so let's say in most deals, particularly small and middle market deals, you'll have one or two notes, good to go. It's hardly holder in due course, meaning you can't sell the note. It's always tied to the performance of the business. Does it collapse? It's really just another holdback mechanism.
So let me attempt to summarize that for the record. In the course of getting a deal done, after that point at which it's now a securities transaction, there are places where a broker needs to take the lead in order to get the deal done. And what are the guidelines in terms of taking that lead?
You know, part of it is under CBI. I think a broker would be well advised to be careful to include an attorney, as Shane was saying earlier. You probably, to keep that on track, would want to include an attorney a little more, maybe an attorney on the same call. If it has been converted into a stock deal, if the discussion, if the discussion isn't about value, so that's the thing, the beauty of the value thing, the value issue is, if you can position it as a discussion about value, or for example, a discussion about employment. Number two, you probably would be well advised to include your attorney a little more often than you otherwise would have to make sure that you're not affecting that transaction.
You want to be able to document this because this will come up in 20/20 hindsight, and you won't have a record of the phone call. You'll have a deposition, and it'll ask the client, well, who raised this issue? Who was talking about this issue on this deal point? And if the answer in the deposition is you, the broker, you're in trouble. Mm-hmm. You want it to be the lawyer who raised it. So maybe you coach the lawyer, and maybe you find some ways of documenting it. You know, lawyers are good at bloviating, which we love, you know, and you just coach us a little bit and we'll run it from there. Think of it as a team. But think of ways of documenting this, because especially when you get into kind of a gray area, this will be a 20/20 hindsight kind of analysis, and you want to be able to point to something that made it quite clear in everyone's mind who was doing the negotiating.
In the MAB proposal, is there a mechanism for sharing fees with registered firms? And then second, do you envision FINRA opposing MAB?
Those are good questions. First answer. We have envisioned that you could share a fee. In fact, the whole point of being able to do that is several-fold. It will take a little pressure off of the registered firms who feel like that we might be taking money from their pockets by letting M&A firms do these things. So the idea is to share compensation upstream and downstream. Make sure that the deal gets to the right size firm with the right skill set, so that, and that only happens if there's some compensation sharing arrangement. And so we have proposed that. Right now, today, FINRA's rules prohibit a member, this goes back to that compensation sharing point I made, NASD FINRA rules prohibit sharing with an unregistered firm. So FINRA would have to change its rule to recognize that an M&A firm under MAB, the proposal, is state registered. You're exempt from federal registration, but you would be state registered, and hence, and FINRA's told us that they wouldn't have a problem informally. They won't tell you that formally. They've informally said we would not have a problem with that because basically the prohibition is to prevent firms from violating the law. And if you're in compliance with the law under MAB, then there would not need to be that kind of prohibition. And they've told us informally that they'd change that. That would not be a problem. Second question, would they oppose our proposal? The answer is no in a couple ways. Number one, it is a quasi-governmental agency. So in and of itself, it's not its role to comment on these kinds of policy-making decisions that the SEC is making on who has to register and who is exempt. So number one, they're not likely to take any role whatsoever publicly on this. Privately, they've made it clear that they are not positioned to regulate thousands of M&A firms. They don't have the resources if all of these firms were registered today. And they would see this as an appropriate way of dealing with the compliance problem. And besides that, as I mentioned, it's a self-regulatory organization. It's not one firm, one vote, because the Board of Governors of FINRA includes a number of public appointments, and it includes representatives of the large firms, as well as a subset of small firm representation. But it would dramatically change FINRA's sort of corporate profile if thousands of M&A firms were to become FINRA members. So no, I don't think they'll oppose it at all. Our Our concern a little bit is that, registered firms might oppose this because they might perceive it as taking money out of their pockets. But that compensation sharing arrangement to get the right size to the right deal to the right people, we believe should ameliorate that kind of concern.
Let's give a very warm round of applause.